Hello, WiCCD members. My name is Shukairy, and I am WiCCD's Education Committee Director. I'm happy to introduce our series, Finding Your Niche. In this series, we will interview female criminal defense lawyers who practice in a specific area within criminal law. The goal of our series is to highlight the work and accomplishments of female criminal defense lawyers, but it is also a way for us to introduce you to specialty areas within criminal law. We hope we can help you find your niche. Enjoy the series. I'm happy to have you on the series Finding Your Niche for WiCCD.
And I'm so thrilled to be here. Thank you for inviting me.
So, Kelsey, I'm going to start with the first question that I always ask my guests, and it's if you can please introduce yourself, tell us about your firm, where you're based, and what kind of cases do you do?
Sure. So I'm Kelsey Sitar. So I'm based out of Calgary, Alberta, in a firm called Sitar and Milczarek, which is a firm I run with my law/life partner, Pavel Milczarek. So we do criminal law and crime adjacent work exclusively. Most of my practice personally is appellate work. It's sort of evolved into being that over the last probably 6 or 7 years. So most of my work is at the Alberta Court of Appeal. But I do some complex case litigation. I do some extradition work as well, and some complainant side representation. So both in the criminal context in 276 and 278 proceedings representing complainants, but also in the civil side when usually women decide that they'd like to pursue civil damages against their abuser. That's something that I assist with as well.
All right, so can we elaborate more on that last point? Because more and more criminal defense lawyers now are representing complainants just because the law has changed and they have standing now in the criminal context. But you actually have this interesting niche where not only do you represent the complainant in a criminal context, in a sexual assault case, you also represent them on the civil side. So can you just please explain to us a bit more about that? What's the difference? And when, like, if a complainant wants to go on the criminal route, does that exclude the civil, or can they go both ways? How does it work exactly?
Yeah, I know it. So it doesn't exclude it at all. And so it can happen in a variety of different ways. Sometimes a victim will decide that they want to participate in something in the justice system or within sort of that sphere of holding their abuser to account, but they don't want to go through the police process. Of course, we hear in the press, and those of us who do defense work know that it's not always quite as dark and gloomy as some of that press would indicate, but certainly going through the criminal justice system is no picnic for an accused or a victim or anybody else. And so sometimes a victim of sexual violence will decide that they'd like to have some agency over how their case proceeds and where it proceeds and what it's about. And so that can be a reason why people will call a lawyer who does this type of civil work and say, I've decided that instead of going to the police, I wish to pursue civil damages. Sometimes it'll happen in a context where there's some sort of existing relationship that maybe has to continue between those two people. And so it can be that,
for example.
yes, exactly. And so sometimes it's that, a victim also knows what will happen to the abuser if the criminal justice system becomes involved. And that's not something that they are interested in seeing happen, but they want that person held to account. So that can be a reason why sometimes it is that they've gone through the criminal justice system and either the result has not been what they've hoped or expected, either whether that's an acquittal or more commonly in the context of something else is offered to the accused. So perhaps it's an assault or a simple assault, right? Or a peace bond, or exactly, the case gets stayed because of delay or whatever the circumstances are. And so that can also be a reason why. Sometimes there's been a conviction in the criminal court, which makes the civil process a bit easier. But then there's still ongoing expenses associated with counseling or, therapy dogs if we have a child complainant, those types of things. So there can be some financial realities that people are looking to address through the civil context. So they can be happening at the same time. They can happen one after another. One can happen without the other. There's a lot of different sort of formulations that we can see in that type of litigation. But oftentimes, I would say it's either that there's been a stay or some sort of result that's been disappointing or concerning. There's some ongoing expenses, or it's just a personal choice that a victim would rather sit in a boardroom with their lawyer and the defendants and their lawyers and have questioning happen in that way, in a process that they can have some control over and agency in deciding to stop if they want, or the pace and flow of that litigation they have a bit more control over.
And obviously, I think what's at stake here is different. In the criminal context, it would be ultimately a conviction and sentence. And in the civil context, the complainant will be getting money, right?
Yeah, we're looking at damages generally. And I mean, frankly, those numbers seem to be going up and creeping up. I mean, lots of civil cases, as we know, settle. And so those numbers aren't things that become public. So it's hard to know sort of where that range is falling right now. But certainly in the sort of reported decision type sphere, the numbers are not high. And so it's really, for most victims, I think, not so much about, a big sort of payday that we might think of when we think of American litigation and you spill your coffee and make $7 million or something. It's not like that at all. It's often, really to recover some of those expenses or to have sort of a notional figure that is an accountability piece for the person that's perpetrated that violence.
All right. And speaking of money here, we know that on the criminal side, now complainants can have a legal aid certificate. Does that apply on the civil end?
No, unfortunately. And so in most of these cases, victims are either paying privately for counsel to assist them with a civil lawsuit, or it's on some sort of a contingency basis, depending on the lawyer that's assisting them. Yeah.
Okay. All right. Now, Kelsey, you also mentioned that you do some extradition work as well.
Yeah.
Also interesting because it's something that we hear about in criminal law. Not a lot of criminal lawyers are familiar with that. So maybe if you can explain to us a little bit, what does that really mean? What do you do when you have an extradition case?
Yeah. So I was really, really lucky to article with and work with Eddie Greenspan while I was still in Toronto before I came west. And so he was one of the people at that time that was doing quite a lot of extradition work. And it was something I didn't even really know was a thing when I came out of law school, frankly. And so I was really lucky to get to do those files and learn from Eddie and now Justice Vanessa Christie, how to do that kind of litigation when I was at the shop in Toronto. And so usually what will happen, it again has various incantations, but either someone's facing a charge in a foreign jurisdiction, or perhaps they faced a charge and were convicted and have left that jurisdiction when they probably shouldn't have, and they find themselves in Canada. And so we have a diplomatic request that comes from the country that wishes to prosecute them or wishes to punish them, that comes through to Canada saying, we believe this person's in your territory and we would like you to send them to us to face this criminal prosecution in our jurisdiction. And so lots of countries we have treaties with, so that's somewhat truncates the process. Even where we don't have treaties with countries, though, there are diplomatic routes through which those countries can ask us to send that person. So what you're doing as a lawyer in Canada under the Extradition Act is assisting that person through the Canadian side of the process. And frankly, it's usually a process that is going to end with that client being placed on a plane or driven across the border or wherever it is that they're headed to face that prosecution. There are safety mechanisms built in, and some aspects of the charter apply, but in most circumstances the test is quite low. It's what most criminal lawyers would think of as the Shepard or Curie test, the prelim sort of standard in most cases. So it's a fairly low threshold for us to what's called commit a person to stand, or commit a person for extradition, similar to committing them for standing trial. And then we have sort of a diplomatic or a more political process that happens after that, which is the minister's decision on surrender. So once a judge in a superior court has said, yes, there's enough evidence, I'm going to commit you for extradition, then we go into the ministerial phase. And that's, I guess, akin for something people might be more familiar with, almost like an H&C immigration application situation where you're raising humanitarian compassionate grounds. You might be raising other sorts of charter issues for the minister to consider, whether it's cruel and unusual punishment. Often, if we're thinking about the states, we can look at someone who's facing, 75 years in prison or something like that under sentencing guidelines. So you're making submissions to the minister to say, okay, this requesting state has a legitimate request for this person, but you should refuse to surrender them or sort of send them to this place. Here's the reasons why. And again, most often the minister will say, well, maybe we'll seek some assurances on some of these things. Death penalty is a common example for that Canada will seek an assurance that the state will not seek it if the person is sent. but generally speaking, the minister is going to say that the person is going to be surrendered. And so then you can get into an appeal process. So you can both appeal the decision for committal under the Extradition Act to the Court of Appeal in the province, and you can judicially review the minister's decision on surrender. And so sometimes those appeals will end up being heard at the same time, if they can be. Sometimes there can be multiple letters to the minister if something shifts about a person's situation. And so you can sort of have a series of judicial reviews. It just sort of depends on the facts of a particular case. But it's really interesting work because you get to learn a whole lot about another jurisdiction's criminal process and how they investigate things and how they prosecute offenses, what sentencing ranges are in those jurisdictions, how they've gathered evidence. Sometimes you're in a position to challenge some of that a little bit at the committal hearing. So it's really interesting. It gives you a chance to do some really different stuff.
Yeah, and it seems to be a niche as well. It's a very unique area, and it kind of also gets a little bit into administrative law, I guess.
It absolutely does. Yeah, it is. And so it's a bit of a crash course in sort of administrative review and all of those aspects. But it's really interesting, and it's very niche, but I would say it's something that people can learn to do. Like we learn all the time how to do sort of new and interesting things in criminal law, because almost two cases are almost never the same, right? And so I always encourage people, if you hear about it, there's some sort of strange rules of the road that you need to know, and so you don't want to do it without mentorship or guidance. But those of us out there that do that work are usually a bit sort of nerdy about it and real excited to talk about it with other people. And so people should never hesitate if you get a call like that and you think, well, I don't think I should do this by myself, but I'd really like to stay involved in this file, or I'd like to sort of have some mentorship and see if I can take it on. I would encourage people to make those connections. And I mean, my phone is always available and people can call because it is really cool work. And you just sort of have to dive in. And as you move through a file, you kind of learn how the process goes and learn by doing. But it's really interesting work.
Well, that's a very nice offer. And actually, Kelsey, where can people find you? Are you on social media? You have a website?
Yeah, I have a website, so you can find all of our sort of contact info in there. I'm also on Twitter. I'm, depending on what's going on, I'm less or more active, but I'm there. So it's just my first name, last name. People can find me on Twitter. And that's probably sort of a good place to reach me too. Yeah.
Okay, so that's for everyone who's watching and who's interested in these cases. Kelsey has experience and is happy to help. Now, Kelsey, I wanted to ask you about one very important subject, because in Alberta, you guys had recently, you've been having or experiencing challenges with legal aid, and to the point that lawyers in Alberta decided to go on strike and not to take any legal aid case. And we've been following this closely here in Ontario because we've been having some issues with legal aid as well. And my understanding from chatting with you before we started recording this interview is that you were actually one of the lawyers who were sitting on the committees who were working on this. So I think many of us are super interested in hearing directly from someone like you who's been involved in this process. If you can tell us a bit more about this, what you guys did, and what happened, some of the behind of the scenes kind of.
Yeah. So it's a discussion in Alberta that's still ongoing. And so to cut to the punchline, I suppose, is that in the end of December of last year, we paused our job action when the government sort of came to the table with something that looked like a good faith outreach while we continued in discussions about other aspects of our legal aid plan here in the province. And so we just have had now, as of April 1st, a new tariff come down, which is, I think, a fairly, and I'll speak for myself on this, I think it's a fairly significant improvement over the tariff that we had operating in Alberta before. It's a bit of an Ontario-BC mashup for people who might be sort of familiar with those two models. But basically what happened, sort of to go back to why job action happened and how it evolved, was the government of Alberta. So we have a sort of tripartite governance agreement that's between Legal Aid Alberta, the government of Alberta, and the Law Society of Alberta that sort of governs how the legal aid plan is supposed to operate. And so it comes up for a midterm review, and then I think it's every 5 years that it's up for a full renegotiation. And so at the midterm review for this particular governance agreement, which was not fall of 2022, but fall of 2021, there was a lot of discussion about the proliferation of self-reps in Alberta courts and how that's bogging down the justice system in all sorts of facets, but particularly criminal and family, and causing a lot of delays and a lot of cost. And so everyone was really pushing that there needs to be a meaningful review of this situation done, of the funding model. We had been in Alberta at a sort of a notional hourly rate of $92.40 for a very, very, very long time. Also operating under a tariff that it was built in sort of the late 70s, early 80s. If you go back to the very first legal aid tariff in Alberta that you can find at the library in a typewritten book, it doesn't look a whole lot different, or it didn't. And so we had sort of tariff items that didn't make a lot of sense anymore.
The circumstance, like with inflation and everything, I mean,
Yes.
maybe whatever tariff we were operating on back then was maybe okay, but right now it's becoming more and more difficult.
Absolutely. No. And like we had the one that I usually give people an example of is a bail hearing in Alberta, which was supposed to cover, your prep, your client call, your disclosure review, your negotiations with the Crown. If that doesn't go well, finding your sureties, going to court, running your bail hearing, was a 1 hour block of $92.40. And so that was what you could bill for a bail application. And so it was very, very broken. So then the government did announce, okay, we're going to do a review of this. But then their direction to Legal Aid Alberta was, you can do a review of the tariff and tell us how you think the tariff could be made better, but you can't touch the hourly rate and you can't touch your overall budget. So basically, the analogy that one of my colleagues in Edmonton, Danielle Boisvert, used was, it's like saying to somebody, okay, you can renovate your whole kitchen, but you have no budget for new appliances, right? Well, what are you going to end up at the end of the day? Something that's equally broken, right? You're just trying to continue to squish everything into a budget and a set of numbers that doesn't work. And so we did our best to push the government to say, you got to put these things on the table. You've got to put everything on the table for this to be a meaningful review, or we're not going to participate, and we're going to look at what other steps we may take. And that didn't go in the way that we wanted it to. We didn't really get any sort of meaningful response from the government. And so we started job action in August of last year. So we tried to start that in a way that would have what we thought would be the most impact in terms of the government taking notice, and it would be something that would be seen and felt, but would have the least impact on Albertans, and particularly really vulnerable people in the criminal justice system. So people who are, arrested but haven't had a bail hearing yet. Those types of folks that really we need to make sure that they're getting access to good representation in those courtrooms. So we withdrew initially, mostly duty counsel services, but not at the bail office. That we have sort of a bail unit in Alberta that deals with sort of first stage, arrests, first appearances in front of the JP and those bail hearings. So we didn't withdraw those folks as part of our initial phase of job action. And that went on for about 3 weeks and it didn't get very far. And so as of September 1, then we withdrew the bail folks as well, all of those duty counsel certs that we had withdrawn previously, that included, I should note, complainant counsel representation, which was something that, as job action went forward, started to cause real problems because 271s and related offenses, they were having trouble having those trials go ahead because they couldn't find counsel to assist complainants on those records or prior sexual history applications. Then in September, when we weren't really getting anywhere with the government, we withdrew on the most serious certificates in Alberta. So we had a different level system then. So it was anything sort of level 2.5 and 3. So homicides, but most sexual offenses, a lot of firearms offenses, things that people would think of as the more serious end of the scale. And then when that didn't seem to be getting any traction, as of the end of September, we then basically stopped taking all new work from Legal Aid.
Right? Like everything.
Everything. That's correct.
Sorry. And Kelsey, was that every lawyer in Alberta just stopped taking legal aid certificates?
So it was not every lawyer in Alberta. There was still certainly some folks that were taking it, but we don't have like the CLA has or in Ontario where you sort of have one organization that notionally represents most criminal defense lawyers. In Alberta, we have 4 different associations. So we have an Edmonton group, a Red Deer group, the Calgary group, and then a group down in Lethbridge in sort of southern Alberta. And so it was a sort of unified front. Those 4 groups came together, which Saddle, the group in the south, is fairly new. But it's the first time we had sort of a coordinated, orchestrated province-wide effort amongst all 4 organizations. So I sit on the exec for the Calgary, the CDLA, but we had this province-wide committee, which I was a part of, that was coordinating amongst all of the jurisdictions. So certainly we had, I would say, buy-in and participation from the vast majority of folks who hold memberships in those associations, which was, in essence, the majority of people who do criminal law as their full-time area of practice. So largely what we saw, there were some folks who chose not to participate, and it's not sort of a union environment. There's not much that can be done. People have to make their own choices, and people have a lot of pressures on them that influence individual decisions around a job action as well. But most of what we saw in the period of time that we were on sort of strike, for lack of a better term, was what we might call dabblers coming in and handling criminal matters. So people who either don't have much experience doing criminal law or didn't have any real experience doing criminal law. We were seeing duty counsel in courtrooms that were predominantly family lawyers. And so it became really hard to watch, honestly, as someone who was doing this. And I think most of my colleagues were doing this not because of our own personal self-interest, although certainly I watch students of mine come out of the University of Calgary who can't have defense practices because they can't afford it. There's just no way to make ends meet on how much work you have to do to pay your bills. But really, we do it because we worry about the type of representation people are getting, that people who don't have to take legal aid anymore aren't taking it anymore. Really good quality senior counsel aren't doing this work anymore. And so to then have to sit in courtrooms and watch what was happening because we weren't there, it was really, really tough. But it was the vast majority, I would say, of people who really do this work were participating province-wide.
And after that last action, because it was a progressive thing, it started off with some duty counsel work that was stopped or interrupted, and then it got to bail, and then it was really the legal aid certificates. But then finally, I guess the government did notice, and they agreed to negotiate, right? Like it did end up being a successful move. So we ended up near the end of September, beginning of October, having a meeting with the government and sort of really trying to make clear that this was just after sort of we'd gone to all certificates and sort of all new work would be refused, trying to make clear that this is a significant problem, and inviting sort of ministers and others to come down to the courthouse and let us show you what's going on and explain to you why you need to sit up and take notice of this and address the situation. And that was when the government initially announced, basically it was an 8.225% increase. And you might think that seems like a weird number, but it's the exact number you need to have to take the hourly rate to $100. And so they gave that bump to the hourly rate and also to what we call the financial eligibility guidelines, or FEGs, which is sort of the cutoff rate for people to qualify, because it was a 2-part job action, not just about the tariff, but also our qualification rates in Alberta are still, they've not adjusted beyond that 8.225%. They're ridiculously low. It's about half of what a sort of living wage would be in most places in Alberta. So you can't make ends meet. No one would even think you'd come close to making ends meet for your family, but we tell you you're too rich to get a legal aid lawyer. So they gave that bump, and then at the end of December came back and said, we'll go to 125 on the hourly rate. We're committing to undertake this really fulsome review of the tariff itself, the hourly rate going forward, sort of in terms of what else might need to be adjusted based on cross-provincial comparisons and the cutoffs and thresholds for Albertans to qualify. And so on the basis of that sort of good faith step, that the government was really willing to put itself out there and to give a substantial increase, then we agreed to pause our job action to go back. And so those ongoing negotiations and discussions are still continuing. The government of Alberta hired a consultant to really dive in and look at our tariff and our hourly rates and the financial requirements to qualify, what legal aid should be covering. And so we're expecting a report on that fairly soon from the consultant and more discussions about what that should mean going forward. Okay, so and it's, as you mentioned, it's still ongoing. So there is also still potential for some, hopefully more improvements.
And we're coming into an election in Alberta, which will be an interesting one to watch. I think even for those of you out east, it's going to be interesting to see what happens. And so, of course, that can shift things in any number of ways as well. So, yeah.
Oh, no, it's definitely something that's of interest here in Ontario, and I mean, it was very interesting to follow the story in Alberta and to see and to hear now more about what was going on a bit behind the scenes. And I wanted to ask you, Kelsey, on this point, did government officials actually go to court to see what was going on, or um, were they
Yeah,
just on
I'm
what?
not aware of that happening. I don't, it may have, like, I don't want to say it didn't, because maybe it did and I don't know. But certainly there were people sort of within legal aid and other places observing from time to time when we would see things. We were trying to keep those lines of communication open as well, to make sure that people were being informed if there was things that were especially concerning going on. And so I know that some of that was observed by some of those folks, and you know, there's always lines of communication between various departments and sort of agencies, but no, I don't. We continued to invite, and still I still invite the minister and the premier to come and see what's really going on the ground, because I do think for those of us who work in the court system, I remember when I first started working in a court and I didn't know a lawyer, I didn't know anything. It's really a foreign territory, and if you don't have sort of a guide there to take you through and explain to you what's going on and what that means and why that's a problem and why that's a concern, everything can look like it's running just perfectly fine. And we have clerks who work phenomenally hard in this province to make it all look like everything is fine, when it's not ideal. It's far from ideal. Yeah.
Well, good luck, and I really hope that the ongoing negotiations will help you get to still more improvements on that front, because I mean, it is important to have a well-funded legal aid system for defense lawyers, because a lot of work, and sadly we're not getting paid enough. So it's that, congratulations on whatever you were able to achieve so far, and I really hope that you'll be able to get even more out of these negotiations.
Thanks so much.
Well, Kelsey, I want to thank you so much for your time. I mean, you really told us today about two niche areas, the extradition and the complainant representation of complainants on the criminal and civil side. So that's really very interesting. And thank you for sharing your experience and your involvement on the legal aid job action. I mean, that's very interesting and important work that you're doing. So good luck for all of that. And thank you for taking the time to be my guest here today on Finding Your Niche.
Thank you so much for having me. It was a great time.
It was nice to meet you. Thank you, Kelsey.